this Friday. First up is 25-4048, United States versus Scott. And we have the honor of having the federal defender with us this morning, Mr. Kamens, whenever you're ready.
Thank you, Chief Judge Diaz. May it please the court. When Raquan Scott was 16 years old, he was convicted of Virginia's use of a firearm during commission of a robbery offense in violation of Virginia Code 18.2-53.1. This statute is not a crime of violence for three reasons. First, the statute requires no substantive connection between firearm use and the predicate offense. Second, the statute does not require that firearm use be directed against another person. Third, the statute does not contain an intent requirement as to firearm use greater than recklessness, particularly with respect to accessories like Mr. Scott. The categorical approach requires the court to identify the least culpable conduct that is criminalized by the statute. It essentially asks the court to answer two questions. First, does that least culpable, I'm sorry.
Can I, you've said the statute multiple times now, and I think it's critically important for my following your argument that I understand what you mean when you say the statute. Because this statute, I understand, the statute we're talking about is the use of the firearm statute. But I think it's common ground that in this case that statute is divisible, one, and two, that in order to be guilty of violating that statute, the government also has to prove that you committed one of the predicate offenses. So when you say this statute, do you mean the use of a firearm statute, or do you mean the use of a firearm statute in a basis in which the predicate offense was robbery?
So, yes, I'm talking about the...
No, that was an either or. Which one, when you say this statute, do you mean either use of a firearm simpliciter or use of a firearm when the charged offense was use of a firearm during the commission of a robbery?
I mean, during the commission of a robbery. So it includes a list of enumerated offenses.
So, so tangibly, it includes, when we talk about what the elements of that statute are, the elements of that statute include both the elements of quote, that statute, but they also include all the elements of robbery.
Correct. Or whatever enumerated offense is at issue in the case. And so in this case, we're not contesting that Mr. Scott was convicted of some other predicate, or that the statute isn't divisible with respect to the enumerated predicates. We are focused on the conviction in this case of 18.2-53.1, limited to the predicate offense of robbery.
So just tangibly, to give one of your 3 points was that there's no mens rea requirement. When you say this statute doesn't have a mens rea requirement, what you mean is this statute doesn't have a mens rea requirement even, or a qualifying mens rea requirement, even when the predicate offense is robbery.
Fair point. Absolutely, robbery has a mens rea requirement. We are talking about a mens rea requirement with respect to the firearm element, because I think that, clearly common law robbery requires the intent to deprive of property. There's clearly mens rea, but what we're talking about is whether the elements established in 18.2-53.1 independently require an intent to use force against another person.
While I don't think you need to look at it independently, I think the better approach would be to combine the elements of the two statutes and see what you have. And what you have is the use of a firearm while taking property from another by violence or intimidation. The use of a firearm, because those are the elements of the robbery. And it seems to me the use of the firearm, use itself may have, under Borden, use is it's an active word. It means not just having it, it means using it. And the Supreme Court has suggested that there is intent in that apart from the normal mens rea of criminal statutes. But then you have the criminal statute. He has to be using the firearm while stealing property from another by intimidation and force. That firearm adds an element of violence, doesn't it, to either intimidation or force?
So no, and the reason, Judge Niemeyer, is that the use of the firearm does not have to be connected to the threat or intimidation.
I'm not suggesting it's connected. I know the Virginia statute on that. What it says is during the commission,
That's right.
while committing, and that court has said the same, it means during the commission. So while committing robbery, so if you have a larceny that develops into robbery, and you have a gun during the larceny phase, that doesn't satisfy it because it doesn't say using a gun while committing larceny. It says using gun while committing robbery. And of course, while committing robbery has the necessary elements of force or intimidation. I'm missing something, I guess, but it seems to me that falls right in what we've done in other courts. I mean, we've looked at robbery with a gun in other states, and the only thing that has preserved robbery in Virginia from categorical crime of violence is the intimidation created by threatened defamation, sodomy, threatening sodomy. The other states don't have that, but Maryland and I think North Carolina, we've said those are crimes of violence. So here, you may still have the intimidation by sodomy, threat of sodomy, but you also have use of a firearm during the commission of that crime. And I'm missing something, I guess, but maybe you can straighten me out.
Yes, Judge Niemeyer, let me say where we part ways. The way that you've just construed the statute is that the firearm must be used during the commission of all of the elements of the predicate offense, and that's simply
Well, if you're lacking force or intimidation, you don't have robbery.
Correct.
You don't. It's just larceny.
Correct.
And so you have to have it. So when you say during the commission of robbery, you have to have those additional elements in there in order to make it robbery.
Correct. But robbery can be broken down into, let's say, 3 periods. First, the larceny. Second, the force or intimidation against the victim. And third, asportation. The use of the firearm can certainly occur during any of that. It's a continuous offense, so it can occur
Except
during
it
the
doesn't
larceny.
work. It doesn't work because if you have the use of the firearm during the theft, that is not robbery. And what could happen in a larceny is you could be in a store with a gun stealing stuff and leave with it. That's not robbery. It comes robbery when the owner comes in and you confront the owner. And so the statute clearly anticipates that the owner has to be there.
Correct, but it doesn't anticipate or require that the firearm be used to exert force or intimidation against the victim. So the
Mr.
firearm.
Kamens, can I, sorry to interrupt you. So I guess the example that you might be getting to, and I apologize if I'm preempting you, is in that very same example, the assailant could threaten the store owner with defamation or sodomy, even though he's armed, commit the robbery, and then have the firearm during the asportation, right? That's
Absolutely, and threaten self-harm at that point, or use the firearm to open up a lockbox and in effect the taking, then threaten reputational harm against the victim, and then engage in asportation. If the cops show up and the assailant threatens to harm himself if they won't let him go, that would satisfy the text and the case law. So the case
law is this Virginia Court of Appeals opinion that's wildly ambiguous about who exactly is threatening who.
Well, I don't want to overstate it. It's an unpublished Court of Appeals opinion, but it does point to a couple things. One, the statutory neighbor, 18.2-53, which contains the element of force against another person. So that is explicit in the immediately neighboring statute. We also have a Virginia Supreme Court opinion in Wright versus Commonwealth, which addressed the construction of the sister statute, firearm use, possession, or threat during commission or while committing a drug offense. And in that case, Wright versus Commonwealth, which the government doesn't respond to, the court said that there is no substantive nexus required between firearm use and the predicate drug offense, because this is very different than the offense in the federal law that you're very familiar with, 18 U.S.C. 924C, which requires not only a durational or temporal connection between the firearm It also requires a substantive connection during and in relation to or in furtherance of the predicate offense.
So can I continue to refine this hypo? Let's put self-harm on the table because I'm not at all sure that I'm convinced of your argument that you can violate the statute by threatening self-harm. But let's do you threaten the store owner by accusing him of committing the offense of sodomy, the common law offense of sodomy, and that in the course of leaving or asportation you somehow use the firearm. Now, in order for that to work here, right? Am I right? You have to, not just that you have to use the firearm in the course of asportation, you have to use the firearm during asportation in a way that is not threatening to the victim of the robbery. Because once it's threatening to the victim of the robbery, you've threatened the victim of the robbery during the commission of the robbery. So I have to use the firearm during the asportation in a way that the victim would not perceive as threatening to the victim?
Correct. And I think, here's an example from Keast, the Ninth Circuit case, which is propping open a window. So, for example, you engage in a threat of reputational harm during asportation, you open up a window and use the gun to prop it open. There is nothing that requires the use of this.
Hold on, but bracketing how it meets the elements. The problem I see with that is, if I was a prosecutor, I would argue the minute the victim of the robbery is shown a gun that the assailant is holding, that is a threat to that is something that any reasonable victim would understand as a threat, right? There's the classic, you've seen Westerns, right? The whole point is to threaten someone with a gun, in some ways, all you have to do is draw their attention to the fact that you have a gun, and that's a threat.
Absolutely. And Judge Heitens, what you're referring to is the implicit threat, essentially, from if the victim were to see a weapon. But it's very clear under Virginia case law, they don't need to see it. And so we're talking about the least culpable conduct. Certainly there are cases where a victim could see the weapon and be afraid, but that's not what's required by the statute. They don't need to see it at all. And Virginia case law is very clear that there's a kidnapping case where the victim is a baby and the defendant argued, hey, this victim never even knew I had a gun. And the court said, no, that's not a requirement of the statute. There's nothing that requires a victim to see the weapon and there are cases also.
Well, how do you detach the weapon from the use of violence or intimidation? In other words, that's an element, and the gun has to be used during that.
No.
That's what makes it robbery. If you don't have violence taking away by violence or intimidation, you don't have robbery. Now, you can have them taken away innocently without violence or and later have the gun, but then you're not using it while committing the robbery.
It's because the parties agree that the offense of robbery is a continuous offense. So if you break it down into time periods. I
understand. It doesn't matter how long. That means you have to be using the gun during. It doesn't say for 1 second. I mean, we're talking about the necessary elements to make it robbery.
Judge
it seems to me, just a minute, take my hypothetical. If you're right, then all you need to do is possess the gun during the larceny phase.
Correct.
And then toss the gun out the window or hide it, throw it away, and the owner comes in and you run away with the thing. The notion, the court has said, for instance, using a gun, this is the Virginia court, if you use the gun after you're leaving while you're escorting, that's not part of the robbery. And so
disagree.
That's a Williams case or whatever. And let me find that case. But the idea is that use is an active verb, and you're using a gun. And if you look at Borden, they've spent a lot of time talking about what use means. When you use a gun during the commission of a robbery, you have to have sufficient elements to commit a robbery. And if you try to fragment it over a period of time, days or whatever, I don't know, it seems to me you don't have the elements satisfied.
Judge DeMar, let me put it this way. If Virginia law required the use of the firearm during the entire duration of the robbery, we would be in agreement. We wouldn't have an argument here, but that's not what Virginia law requires. So in your hypothetical, if a defendant uses a firearm to initiate the larceny, to obtain money from a lockbox, for example, and then throws the gun away, then is confronted by the store owner and makes a reputational threat to commit the robbery.
He didn't use the gun during the robbery. He used the gun during the larceny.
The larceny is part of the robbery. It's part of the elements. It's the case law is very clear that it is part of the robbery, Judge Niemeyer. And
sure, it's part, but it's not a necessary, sufficient part. There's no
That's right.
robbery. He used the gun during larceny. He did not use the gun during robbery. To commit robbery, you have to go further. You have to take it away from somebody by force or intimidation. And you used a gun during that thing. I can't understand why that doesn't fit. In other words, the only reason Virginia robbery is not a crime of violence under our precedents is the use of the threat of sodomy, defamation, threatening sodomy. And when you put the gun in, regardless of whether sodomy is present, you now change Virginia robbery to fit armed robbery in almost every state that we've found, the use of a gun during the commission of a robbery to be a crime of violence.
May I answer?
Absolutely.
Sure. Well, that's up to the chief. Yeah.
Chief Judge Diaz.
Yes, please.
So Judge Niemeyer, respectfully, you're adding an element of a requirement that the firearm be used to effect force or intimidation on the victim, and that's not required by the text or the Virginia case law. It merely needs to be used during the duration of the robbery, which includes the larceny portion, it includes the violence and intimidation portion, it includes the asportation. If firearm use at any point during the robbery is used for any reason, even unrelated to the predicate offense, to scratch your head, that's a use. That is sufficient to satisfy the elements.
And what is the case that says that makes that point of law?
So there are two. Rose is a Court of Appeals opinion that cites the U.S. Supreme Court case of Bailey about use. And in a case called Smith versus United States, I think it's Justice Scalia in dissent with the majority has a debate about what's a use. And they say, well, even, scratching your head could be a use. But in 924C, which is the statute they were talking about, that wouldn't be sufficient to violate the statute because scratching your head doesn't have any relation to the predicate offense under 924C. And so
the reason I ask that is because it's clear, obviously, under Virginia law that making an accusation of sodomy is enough to warrant something less than the generic definition of the federal offense of robbery. But we also have cases that say that there's got to be more than a theoretical possibility of an offense being committed in the way that a defendant would like to have it described. So aren't we getting a little bit far afield now and getting into theory as opposed to practicality?
So I think the question for the court is, have the Virginia courts, either from the plain language of the statute or from their case law, greenlit a prosecution that is broader than the force clause? And that's clear here. There is nothing in this statute that requires use of a firearm against another person. And certainly in the context of this case, with an accomplice who isn't even required under Virginia law to know that a Confederate has a gun with advanced knowledge, there is nothing in this statute to establish either the mens rea or the use of force against another person.
Can I just ask you one final question before you can think about the case I was thinking about? It's not Williams, it's Rowland versus Commonwealth. And in Rowland, the Virginia Supreme Court said that it was insufficient to support a conviction for use of a firearm in the commission of burglary when the elements of the burglary were completed before the use or display of the firearm. So it focused on all the elements of the burglary in assessing the use of the firearm and requires the use of the firearm during the elements that constitute a burglary. And if it was used before or after, under this case, they keep focusing on committed during, while committing, they say during, and it says it doesn't include the acts that do not constitute the elements. And so I suggest that you have to have sufficient elements committed to satisfy the burglary requirement when it says while committing burglary. And it seems to me that's pretty logical opinion too, isn't it? How do you can think about it and come back. I don't want to drag it out. But
Chief Judge Diaz, can I respond briefly about
Rowland?
Sure, go ahead.
Rowland is a burglary case which is completed as soon as a person makes an unlawful entry with intent to commit a felony, and then it's done. It is not like robbery, which is a continuous offense that starts with the larceny and ends with the asportation. So burglary is very different from robbery. And secondly, Rowland said if the person used a gun to effect entry during the burglary, that would have satisfied 18.2-53.1, meaning you could effect the entry by using a gun against property. And
Yeah,
so
but see, the important thing is they focused on the elements, not on the factual difference between burglary and robbery. The fact is you need to satisfy the elements of the predicate crime or the incorporated crime. And in our case, we have robbery. In that case, you have burglary. But the important point of that opinion is that the possession of a use of a firearm during the commission of burglary or robbery means you have to be during the elements that make it burglary or robbery.
if I may, the burglary ended as soon as the person effected entry, and that's when they pulled out a gun. And so in that case, they said burglary is over. You used a gun afterwards. It wasn't used during the burglary. So in the robbery context, it starts with the larceny, ends with asportation. And so at any point during that time you use a gun, it satisfies the statute. Burglary is a very different offense, and Roland is a good case for us, actually.
All right, thank you, Mr. Kamens.
Thank you.
Ms. Bachara?
Good morning, and may it please the court. Jacqueline Bashara for the United States. I can start, as my colleague did, with the mens rea question. As Mr. Kamens recognized, the predicate felony here, robbery, requires knowledge as to the actus reus. That's clear from the Supreme Court's decision in Carter. Relying on Carter, this court has consistently held with respect to federal and state robbery offenses that the requisite mens rea is something greater than recklessness and therefore satisfies the force clause. That's true beginning with McNeil, Doctor, Burns Johnson, Salmon, and as recently as Shanton. So my friend never explains how the addition of the use of a firearm element to the underlying felony of robbery, which by necessity requires a sufficiently heightened mens rea, adding the use of a firearm somehow takes the compound offense outside of the force clause. It just doesn't make sense. Instead, this court, in other cases like Bryant and Thomas, recognizes that the addition of a weapons element actually confirms that an offense satisfies the force clause. So necessarily, and Judge Niemeyer, you are correct that the categorical approach requires the court to assess the elements of the offense as a whole, not to piece them out individually. That's true, from cases like Allred, Runyon, and Roof. The court has consistently said that the court is going to look at the elements of the offense as a whole in determining whether there's a sufficiently heightened mens rea. The court should do the same here and hold that the compound offense necessarily satisfies Borden.
So let me give you a hypo about the compound offense that I think satisfies all the elements of this offense. And let me ask you if you think either A, it doesn't satisfy the elements of the combined offense, or you think this isn't a problem. So the hypo is, I want to rob someone in their house, and in the course of doing that, I need to get into their house. So, I mean, I know that's a burglary, but I'm just going to commit a robbery here. And so what I do is I get into their house, and I worry that the door is going to close behind me. So I use a firearm to prop open the door as I go in, to make sure that I have a way of getting out after I rob them. So I go in through the front door, I use my gun to prop open the door. I then go into the victim's kitchen and I say, give me all of your stuff or I will tell the world that you are a person who's committed the crime against nature. They then give me all their stuff. I then leave it, and then I come back to my firearm, which I very carefully left in the place to facilitate my escape. I pick up the firearm and I walk out. Do you think that person has committed every element of the combined offense under Virginia law?
No, Your Honor, I don't think that qualifies as a use of a firearm within the scope of 18.2-53.1 for a few reasons. First of all, Rose versus Commonwealth says that the use must be, quote, intended to cause physical injury. The Court of Appeals there was relying on the Supreme Court of Virginia's decision in Holloman, which says that 18.2-53.1 is aimed at preventing actual physical injury or death and to discourage criminal conduct that produces fear of physical harm. We know the Supreme Court of Virginia in cases like Yarborough has also said that this statute, 53.1, because it's a penal statute, the courts will always construe it narrowly. When there's any doubt about its potential scope, it's going to be construed against the Commonwealth and in favor of the accused. I would submit that includes as to what constitutes a use. And broadly, when courts are construing the meaning of use, the Supreme Court, as early as Bailey and as recently as Dubin, in interpreting what use means, has applied the canon of nos geta socis, right? A word is known by the
that's how
company
this,
it keeps.
but
And
here we're not interpreting a federal statute, so I'm not sure how the Supreme Court construes federal criminal statutes necessarily tells me how the Supreme Court of Virginia construes Virginia statutes.
that's a fair point, Your Honor. However, the Virginia courts have looked to the Supreme Court's decisions in Bailey and Smith in interpreting what use might mean. And so I don't think that nos geta socis is sort of like limited to interpreting federal statutes. That's a general canon of statutory interpretation. And here, use or attempted use is paired with display in a threatening manner. And so our position is that they must be construed consistently, right? Use is circumscribed to something that is similar or akin to displaying a firearm to the owner of property in a threatening manner, at least when we're talking about the compound offense of robbery.
Can I just ask you one close-off question on that hypo? Thank you, that was all very helpful. So your argument, as I understand it, is that hypo doesn't violate this statute. That's broadly the response. And
Right.
so just to be so counterfactually, and again, you're not going to concede that I understand your primary submission is that hypo does not violate this statute. If we were to conclude that hypo violates this statute, would you have a categorical match?
All right, so if we're talking about Borden, I think that
No.
that's
I'm
still-
not talking about Borden. I'm saying that the
We're talking
hypo I
about a
gave
use
you
of
involving
force.
propping the door open, all of that, and let's say hypothetically we certified to the Supreme Court of Virginia and said, does that violate this statute? Has a defendant who did that violated this statute? Have they used a firearm during the commission of a robbery? If the Supreme Court of Virginia said the answer to that question is yes, would there still be a categorical match in the government's view? I think
if
no.
the firearm is propping open the door and the owner of the property
Never sees it. Not
never
once.
sees it, no.
Okay. I thought so. I just wanted to clarify.
So Ms. Bachara, what is it that Mr. Kamens is getting wrong about his notion that because robbery is a continuous offense, that the use of a firearm can occur at any point in that continuum?
So if we look at the continuing offense cases, the point that they're actually making is a distinction, as I think Judge Niemeyer was getting at, between larceny and robbery, in that basically the asportation might not occur until the owner of the property or someone in constructive possession of the property has been fully severed of absolute control and possession of the property, right? And so the distinction I think that's important is that, yes, a person can take an item from someone's person or presence, perhaps in a way that doesn't necessarily, as Mr. Kamens posits, it might not be at that moment that the person uses force, but all of the cases that are cited in the briefs, at the moment where someone confronts the person who is trying to take away the property, the person uses either violence or intimidation to effect absolute control over the property. And that is the moment when the courts consistently use the phrase, it matures into robbery. It is not robbery until there has been this use of force or intimidation to effect absolute control over the property from the owner or someone in constructive possession.
And so your point is that even if someone commits that offense by threatening slander or reputational harm via an allegation of sodomy, that because the firearm hasn't yet been used in that instance, it doesn't satisfy the requirements of the Virginia statute?
Right. So if the hypothetical person approaches the owner of property and makes a threat of a sodomy accusation, and then, I guess, starts walking away or something, and then subsequently uses a firearm kind of to say, no, really, I'm not giving this back to you, that's when the robbery, the asportation is complete, when it has matured into a robbery and not just larceny. Right?
Okay.
The use of the firearm is kind of the critical distinguishing feature. I think Judge Niemeyer was pointing out that the only reason that Virginia robbery has been held to fall outside the force clause is because of this potential sodomy threat theory. But once you add the elements of the use of a firearm offense, there's just no conceivable way to commit this offense in a way that doesn't require a use, attempted use, or threatened use of force. And you're correct, Chief Judge Diaz, to note that the realistic probability test from Duenas-Alvarez continues to have force here. The defense has never identified any case, not even dicta in any case, where a Virginia court has recognized that a defendant could be convicted under 18.2-53.1, but based on a sodomy threat theory of robbery.
So can I ask you, bracketing for the sake of bracketing, that I'm fully aware that under the categorical approach, we don't look at the specifics of his offense. This is more of for a possible assumed harmlessness error issue. Do you agree that the district court was just wrong when it said that Mr. Scott used a gun during his previous offense?
Yes, Your Honor, and I would note that my colleague affirmatively corrected the district court and pointed him to the facts recounted in the PSR to make clear that the defendant was not personally the one who was holding the gun during the predicate offense.
And so to the extent, for purposes of an alternate variant sentence, the district court cited that he was using a gun, that's a wrong factual premise, right?
That is incorrect.
Okay.
Yes. Of course, we have made a harmlessness argument here for the reasons we asserted in our brief. Well, the district court made clear that it would have imposed the same sentence regardless, and for the reasons we asserted in our brief, it would be substantively reasonable. The defendant has never really engaged.
But is that enough? I understand. So the problem is I've looked at our cases and we say two different things. We say that the alternate sentence has to be reasonable, and then sometimes we say it has to be substantively reasonable. And I will bracket that you can cite cases that say substantive reasonable, and I'd ask you to bracket that I can cite cases that just say reasonable. Why wouldn't it also have to be procedurally reasonable? Because, I mean, thinking through this, right? Like we say, take a step back outside of alternate variant sentences. All sentences have to be procedurally and substantively reasonable. Gall says that, Rita says that, all kinds of cases say that, right? And so then sometimes the district court imposes what it thinks is a procedurally reasonable sentence, and then but they recognize that, look, there's appellate review, and we say a lot of weird things about the ACCA. I still don't understand how we said what we said in Parham, but here we are. So the district court says, even if I got something wrong, I'd still do the same thing. Mm-hmm. It doesn't seem to make sense to me that it's just enough to ask whether that same thing would be substantively reasonable. Why wouldn't that same thing also have to be procedurally reasonable too?
Well, because, Your Honor, the premise, I guess, of this assumed error harmlessness inquiry is that there is a procedural error to begin with.
Well,
right?
okay,
So
let me
there's
take a
no
step back.
counterfactual.
Well, no, but here's the counterfactual. Here the district court said, I've concluded this enhancement applies. And having concluded this enhancement applies, I'm giving a within guideline sentence. And then, but the counterfactual is, what if I'm wrong that this enhanced sentence applies? Well, then the district court has to explain why it's imposing an above guideline sentence to be procedurally reasonable. I just don't understand how you can get around, like, if you commit one procedural reasonableness violation, that's no big deal, as long as you commit another unexplained sentence, and that would be substantively reasonable. That just doesn't make any sense to me. And the reason I say all this matters, I won't hide the ball. Like, I don't understand how this alternate sentence would be procedurally reasonable, because if I assume the district court got the enhancement wrong, I don't know what its explanation of imposing an above guideline sentence is, other than just saying, I would do this.
Okay, I think the distinction that I'm making, or that I see, is that if we assume that the district court erred in calculating the guidelines range, you still have as a point of comparison what the guidelines range would have been, for example, had the enhancement not applied. And so you can compare the sentence actually imposed to the counterfactual other guidelines range and assess, okay, is this substantively reasonable? But
I agree, I can do all those things. I just don't.
A new calculation of the guidelines, there's no.
No, not a new calculation of the guidelines. I mean an explanation from the district court. If this were an above guideline sentence, I would impose an above guideline sentence because, right? Why would I impose an above guideline sentence? And all I really have here is the district court saying it would do it, and also seemingly getting the facts of the defendant's case wrong. And so now I have real concerns about whether that alternate variant sense. Again, this all presupposes that you're wrong on issue one, and I know your threshold arguments, you're not wrong on issue one. But if we're having the harmless error inquiry, we're positing that you're wrong on issue one. And if that's true, I don't understand what the district court's explanation for imposing an above guideline sentence is.
The district court was very.
Didn't the district court refer to the man's criminal history and a similar type of dangerousness to justify the sentence as a variance sentence?
That's correct, Judge Niemeyer. The district court also repeatedly.
This is where the district court got the defendant's criminal history wrong.
I mean, it's not the history that's wrong. It's just the facts of the underlying offense the district court seemed to misremember. But I would add that multiple times during the sentencing hearing, the district court emphasized the fact that the defendant committed this firearm offense just 3 months after he had been released from state prison for serving 16 years in total for the robbery and use of a firearm offenses, as well as the offenses that he committed while he was in the Department of Corrections. And so that was a driving force behind the district court's reasoning.
Can I follow up with, on Judge Hyten's point and Judge Niemeyer's response? I too was concerned about, well, initially I thought that there might be a basis for affirming based on harmlessness, but when I went back to look at the sentencing proceeding in this case, in addition to the issue that Judge Hyten's presented, it seemed to me that when the time came to announce the sentence, all the court did was simply recite the existence of the guidelines, but didn't apply the relevant facts to those guidelines. It just seems to me to be procedurally deficient on its face, even absent, anything else going on in this case.
So just to take a step back, I would remind the court that the defendant is not actually raising a separate claim
I
of
understand that,
procedural error.
but this is in response to the government's claim that the sentence is harmless, and to Judge Hyten's point that should we just look at substantive reasonableness or maybe both? And if you look at page 109 of the transcript, I mean, it's 2 paragraphs. It's just a recitation that the sentencing guidelines were properly computed, and I'm considering them to be advisory. And along with the factors set forth in section 3553, this is the sentence that I'm going to impose. That's it. I mean, that by itself seems to me deficient on its own, had an argument been raised, even though this is a guidelines sentence. But then when you layer on top of that now, if we agree with Mr. Kamens on the first point, and I know you have pretty good arguments as to why that's not correct, now you've got an above guideline sentence and virtually no explanation.
So I think I understand the court to be focused on the moment when the district court actually announced its sentence, but if you go back earlier in the transcript, the district court pretty carefully walked through the 3553A factors, going essentially through the PSR and recounting obviously the nature and circumstances of the offense, the defendant's criminal history, or his history and circumstances, recognizing. And so this court, when evaluating procedural reasonableness, doesn't look only at the moment that the sentence is imposed in isolation. The court considers the sentencing transcript as a whole in assessing the district court's analysis.
Now, are you saying that the district court did all that, or the prosecutor did all that? Because I mean, I read the transcript. It didn't seem to me like the judge said much of anything, but maybe I'm missing that.
My recollection is that the district court did assess at least the basic parameters, the 3553A factors, before it actually imposed the sentence.
Oh, okay. I see what you're saying.
And I gather that you're saying there wasn't a sufficient kind of like reference back to those factors when the court actually imposed the sentence, but that's not what this court's procedural reasonableness cases require.
But the court did say, it says, based upon the record at hand, including your criminal history.
Yes.
And it seems to me the record at hand is the record they've just been talking about, isn't it?
Yes, that's correct, Your Honor. I'm not hearing other questions on the merits. I just wanted to, with respect, ask that the court reach the merits and not just dispose of this case on harmlessness.
So can I give you another hypo then? This doesn't involve individual facts. This is a state law prosecution where the following happens. So again, for the sake of argument, imagine this highly unorthodox, strange proceeding. Do you imagine a case in Virginia State Court where at the beginning of trial, the judge says the parties have members of the jury, the parties have stipulated to two things that I'd like to stipulate to. It is stipulated in this case that this defendant committed a robbery in violation of Virginia law. The defendant stipulates he committed a robbery in violation of Virginia law. And the parties also stipulate that during that offense, the defendant used a firearm. It is stipulated to that. Based on that facts, and the defendant is thus convicted, because I think at that point the defendant has stipulated to every element of the combined offense under Virginia law. At that point, does this enhancement apply? Those are the only stipulations.
The guidelines enhancement?
Yeah.
Or
Yeah. You know nothing about the facts of the defense of this case. It is stipulated that those things are all true. Your view is yes, right? I think?
yes, because that's the nature of the categorical approach. The court focuses on the elements of the prior conviction, not the facts.
And when the defendant says the enhancement doesn't apply because how do you know that I used it against the person of another? What does the government say? And by the way, there's no like, how do we know that? I mean, I guess it's just because inherently there's no way to not do that. I just want to make sure I understand that there's literally no way to do that, in your view, without having also triggered the enhancement with the guidelines?
Correct. So my understanding of the defendant's arguments is that use is sort of this broad, all-encompassing term that could hypothetically, on some set of facts, involve a use that is not actually accomplishing some kind of threat or intimidation of the victim. And our position is that that is not a way, Virginia case law does not support that interpretation of the word use. And so categorically, to violate this compound offense, there must have been a use, attempted use, or threatened use of force. The facts of a particular case are irrelevant under the categorical approach.
Ms. Bechara, before you sit down, there was a case that was cited by Mr. Kamen's Wright versus Commonwealth, and he asserts that that case holds that there doesn't need to be any nexus between the firearm and the predicate offense. And I don't know that you addressed that case in your response brief. Is there anything you'd like to say about that, or why his view of that case is wrong, or why it doesn't apply in this case?
I can address that briefly. I see I'm over my time.
Please.
Okay, so Wright was actually interpreting a different statute. It's 308.4 paragraph C, which is similar to 924C, but it's limited to predicate drug crimes. And the distinction I would make there is that that offense also applies to possession, mere possession of a weapon. But the Virginia's case law is clear that 53.1 does not apply to mere possession. There must be a use or attempted use or display in a threatening manner. I think Judge Niemeyer was correct in my friend's opening to say that use connotes some kind of active employment. And so the use while in the commission of the robbery, even if there is no, the statutory language doesn't contain the words like during and in relation to or in furtherance of, that is not dispositive of the issue here, because in order for someone to actively employ a firearm while committing robbery, there's necessarily some kind of force or attempted or threatened force.
All right, thank you. Do my colleagues have any other questions?
No.
Yep. All right, thank you very much, Ms. Bechara. Mr. Kamens? I think you're on
You're
mute.
muted.
Sir.
Can you hear me? Let me start where my friend ended with the definition of use. Rose versus Commonwealth is the leading case in Virginia, and it says that Virginia courts are obligated to give use its ordinary and plain meaning, and it cites Webster's, which defines use as to employ for some purpose, to put into service. It also cites Bailey, which says the active employment understanding of use certainly includes brandishing, displaying, bartering, striking, and most obviously firing or attempting to fire a firearm. So Judge Hyten's hypothetical of propping open a door with
Okay,
a gun.
but what about this language? What about this sentence from Rose that I'm sure you're familiar with because the government quotes it? Once the object satisfies the definition of the firearm, comma, any use of the firearm that is intended to cause physical injury is a violation. Now, I understand that's a case in which the defendant used the weapon as a club. And so I guess I think the government is suggesting that that sentence means only if it is used in a manner that's intended to cause physical injury. Am I correct that your view would be all Rose was doing was rejecting the defendant's argument in that case, and because that defendant had clearly used it as a weapon, the court just says, like, used it as a weapon, go away, that constitutes use?
Absolutely, and that's exactly how the analysis goes. They say this term use is incredibly broad. It says use for any purpose, and certainly use of a firearm that's intended to cause physical injury, that necessarily falls within the bucket of things that constitute uses. And so it doesn't mean that all of the ways that you use a firearm necessarily have to be intended to cause physical injury. It just means that is certainly among all of the ways that you can use a firearm. That's probably the most common way, but it's not the only. And that's why Virginia courts say use is anything. And your hypothetical, Judge Hytens, is exactly correct that propping open a door or a window is just as much of a use as firing it into the air or into the ground or against a victim. All of those are uses. Not all of those are uses against a victim to intimidate or use force. Secondly, with respect to mens rea.
Mr. Kamens, before you get to mens rea, can you talk about, you cited a Supreme Court case named Ressam, and you said that it supports your view, Ressam, that the Virginia statute is broader than the generic offense in the federal statute. And the reason, but in that case, the provision, and I'm going to quote it, prohibited the carrying of an explosive during the commission of any felony. Carrying, to me, does not connote the same kind of active action that use does. So why is that case at all helpful here?
So Ressam is just like Wright. It's the federal version of Wright. It's construing 18 U.S.C. 844H, and that's unlike 924C. It doesn't require any substantive nexus between the explosive in that case and the use or carrying. And so it's just like Wright versus Commonwealth. Now, my friend said Wright is different because that statute 18.2-308.4C includes possession. But in Wright, it said, look, none of the verbs in the statute necessarily require a substantive connection with the predicate offense. And the same analysis is used in Ressam that, again, the government, I think the defendant in that case, actually, Mr. Ressam, was arguing, look, my predicate offense here is obstruction, and the carrying of the explosive had nothing to do with my commission of the obstruction offense. And I think it's an opinion by Justice Stevens who says the statute doesn't require it. It doesn't say during and in relation to. It, just like Wright, cites 924C and says this is not like 924C, which requires a substantive nexus between the use or carrying of a firearm and the predicate offense. So our statute, 18.2-53.1, is just like the federal statute, 18 U.S.C. 844H, and like the sister statute involving firearm and drug predicate under Virginia law. So the fact that there's another verb in the sister statute under Virginia law, which, by the way, I think we cited at the Virginia practice commentary on jury instructions, says these are analogous statutes, 18.2-53.1 and 308.4C. They're just mirrored components that are contained in one statute in the federal statute 924C. So the reason that Ressam is helpful is because it's like Wright. It shows that when you just have a temporal relationship between the firearm and the predicate offense, that doesn't require you to use the firearm in connection with the federal offense. Quickly on mens rea, if I can give an example. If two people agree to steal from a church leader, and they go into the church leader and they say, hey, we're going to tell the entire church that you're engaging in crimes against nature unless you give us the donation plate. And then one Confederate, unbeknownst to the other, pulls out a gun. There's no mens rea required to hold them both accountable, both for robbery and for 18.2-53.1. unlike federal law, Virginia law doesn't require the defendant who doesn't know about the gun to know about the gun or to have some foreknowledge or intent. Just to be clear, Virginia law is different from federal law in that respect and doesn't require any mens rea with respect to the firearm element for accomplices. My time is over, but I'd like to say a word about harmlessness.
Very quickly.
Okay, quickly. The way I understand the harmlessness inquiry, it goes back to this court's decision in Savillon Matute, which is cited in the government's brief. And I think it requires judges to create a record saying, let's say I'm wrong on the guidelines. Let's assume the guidelines are as the defendant says it. Here's why the record supports the upward variance that would be imposed. In this case, I think as you've recognized, the district court got the facts wrong and didn't provide anything on the record to establish why the guidelines should be doubled, essentially, in this case. We'd ask the court to vacate and remand for resentencing.
Okay, well, thank you both very much for your able arguments this morning. I think they were both quite helpful to us in this tricky statutory maze that is the categorical and modified categorical approach.
Thank you all.
So we typically come down and greet you personally, but we can't do that.
Good morning, Your Honors. May it please the court. My name is Sarah Noakes. I'm here on behalf of the United States asking you to...
I'm sorry, before you jump right into it, I want to be sure that the audio and recording is working. Wendy, are we good?
Yes, sir. We should be fine.
Let me announce the case and then you can fire away.
Thank you.
Our second case is 24-4604, United States versus Allen. Now you may proceed, Ms. Noakes.
Thank you, Your Honor. We are here asking you today to reverse the district court's decision suppressing the evidence. Here, the drugs and guns found in the defendant's bags at the time of his arrest would have been inevitably discovered. During any one of 3 lawful inventory searches his property would have undergone prior to his being locked up in the Wake County Detention Center. And the court clearly erred here in finding otherwise. Inevitable discovery requires the government to prove by a preponderance that police would have completed 1 lawful search, which would have uncovered the evidence. Here, the government presented uncontested evidence of 3 lawful searches or search opportunities, every one of which would have uncovered the drugs and guns.
Are you aware of any case where this court has ever reversed a district court's holding that something wouldn't have been inevitably discovered?
No, Your Honor, I am not.
And that's because clear error is a really high standard of review?
Yes, sir.
From which the government routinely derives substantial benefit in criminal appeals?
Yes, sir, Your Honor. It is odd for us to be on this side.
Okay.
Yes. But the evidence, again, uncontested before the court, showed that both the Raleigh Police Department and the Wake County Detention Center would have conducted searches, particularly inventory searches, at the scene of the crime, upon the defendant's arrival at the jail, and again, when he didn't bond out from the jail.
Hey, before we get into that, I'm sorry, to do the thing that I think you, with some fairness, accused the district court judge of doing, but to do it again, what in the literal heck were these officers thinking? Because there were multiple Fourth Circuit decisions that suggested you absolutely cannot do the thing that they did here. Like, why are we even having an inevitable discovery? Because Davis makes 100% clear this is not a valid search incident to arrest, and Buster makes 100% clear this is not a valid Terry search. So how in the world did they think this didn't violate the Fourth Amendment?
Your Honor, I think that this is a sliding scale type of reasonableness inquiry, right? You have cases like Farabee, where the defendant was secured in handcuffs and outside a home when police searched a book bag inside the home, and this court found that he could have somehow reached the book bag. Of course, in Davis, which actually came from this district, the court found otherwise. When a defendant was on his stomach with his hands handcuffed behind his back, that was a situation where he couldn't have reasonably reached this evidence. Here we have a defendant
and Buster makes very clear this is not a valid Terry frisk.
Yes, Your Honor, this was an arrest. Absolutely.
I'm just, again, I know this maybe, by hypothesis, once we're doing inevitable discovery, we're assuming they violated the Fourth Amendment. But I don't really understand how they possibly could have thought they were allowed to do this.
Well, Your Honor, they had just fought with this defendant for about 5 minutes. It took, between 3 and 6 officers to get him subdued and secured on the sidewalk there. And then somewhere between 15 and 20 minutes after they actually got him in those cuffs, they conducted this search of these bags that were, to be clear, about 2 feet away from his foot.
15 minutes after we've cuffed someone, we have to search their bag.
Yes, sir, Your Honor.
Okay.
Yes. And certainly we are not contesting that the district court got the search incident to arrest analysis wrong. We've made a preservation argument because we believe that the Supreme Court could decide Davis situations differently, along with the First Circuit and Supreme Courts or courts of last resort in other states would have called this a good search incident to arrest. So just as reasonable legal minds can differ on this point, as our colleagues do in the First Circuit, for example, I think it's not completely unreasonable or crazy for the Raleigh Police Department officers to have considered this a search incident to arrest. At any rate, that was their primary justification for this search of the bags, although they also indicated at the time of the search that they were also doing this as an inventory search. In the district court, the government offered evidence of the Raleigh Police Department's inventory policy, including their written inventory search policy and testimony of 2 officers who were trained in that policy. And that policy requires any personal property in the possession of an arrestee to be searched in inventory. It applies to all property in possession of every arrestee who is bound for the jail. There's no discretion here. All of that property is going to be searched. So based on Raleigh's inventory policy, law enforcement officers certainly could have conducted a lawful inventory search, which would have revealed the guns and drugs here. And the evidence showed that if Raleigh officers hadn't searched the bags incident to arrest, they would have searched them per the inventory policy. We know that because they actually did. That was their secondary justification for the search of the bags at the scene. So in Alston, this court told us to look to 2 things when we are determining whether there's a valid inevitable discovery search: whether the officers could have done a lawful search and whether they would have done a lawful search. And it's clear here that Raleigh could have, according to their policy, and that they would have because they actually did.
Well, wait, hold on. The could have question isn't what their policy says. The could have question is, would the Fourth Amendment have allowed it, right? Isn't that that's the could have question for inevitable?
Yes, Your Honor, I agree with you. Yes. Certainly the policy comes into it because inventory searches require standardized criteria.
Ms. Noakes, can I interrupt you? And you raise a good point about the fact that the Raleigh Police Department had its own policy, because the district court seemed to be caught up with the notion that there wasn't evidence of a Wake County detention center policy, at least written evidence. I think the policy was described at the hearing, but even if that could somehow survive clear error, I don't see how that would matter if the Raleigh Police Department had its own policy to search following an arrest, which is exactly what happened here, right?
Yes, Your Honor, exactly. We believe that this evidence of Raleigh's search, Raleigh's policy and Raleigh's search is sufficient standing alone to show that this evidence would have been inevitably discovered. And I would also note that to the extent that the district court's order required the government or faulted the government for not introducing Wake County's written policy, that was error. This court has been very clear in cases like Clark and Bullett that introducing a written policy is not and never has been required. Nonetheless, the government did introduce Raleigh's written policy. And again, that Raleigh search, that inevitable inventory search that Raleigh did at the scene, was itself sufficient to show that this evidence would have been inevitably discovered. But the government, as we know, it didn't stop there. It also presented evidence that the Wake County Detention Center would have done its own searches, 2 separate searches, which also would have uncovered the evidence if the evidence had made it from the scene. We know it didn't go with the defendant to the jail because it had already been searched and inventoried and secured by the Raleigh Police Department, right? But the inevitable discovery doctrine deals in hypotheticals. So it's relevant to think about what would have happened if Raleigh hadn't done its search and hadn't secured the property. What would have happened at the jail? And to support the policy of Wake County Detention Center, the government offered testimony of a jail lieutenant. We did not offer the written jail policy, but this jail lieutenant who testified is somebody who has several years been an intake in the Wake County Detention Center and is enough of an expert in this particular policy that he's charged with training other Wake County Detention Center staff in how to do these types of searches and procedures when arrestees come into the jail. So that officer, that lieutenant, testified that when folks come into the jail, they're initially told to remove all of their outer clothing and remove the items from their pockets, and then their persons are subjected to a pat-down search. But their property is searched both by an arresting officer and by a Wake County Detention Center staff member. At that point, when defendant came into the jail, during that initial search, this evidence would have been inevitably discovered. There can be no argument that the Wake County Detention Center staff would have somehow missed 2 guns, for example, in the defendant's bags. So once again, we have another opportunity at which time this evidence would have been inevitably discovered. But the lieutenant also testified about a further search, or here in this case, a third search that would have occurred. When arrestees don't bond out of the jail, there's another sort of more fulsome inventory search done. And I would note for the court that we know that this defendant did not bond out of the jail on the day of his arrest. That's in docket entry 21, the pretrial services report. And the government apologizes that this was inadvertently left out of the joint appendix, but we did provide a copy of this to defense counsel ahead of argument here today. So we know that the defendant didn't bond out of jail, and the Wake County Detention Centers would have, as the lieutenant said, quote, gone through all of their property once again and keyed in a list of items of their property into the system. So somebody at Wake County would have gone through every piece of that property, every pocket, every piece of that property, and taken a look at exactly what was in those bags and then made a list of it in the Wake County system. And once again, of course, they would have found the guns and drugs at that point if they hadn't somehow been discovered in the 2 inventory searches that would have occurred before that. So because of that, it's clear that the Wake County Detention Center staff could have lawfully done an inventory search, which would have revealed the defendant's property. And we also know that they would have. Per that same jail lieutenant, there's no discretion in this particular policy. It's done for every single arrestee that comes into the facility for every offense, right? It's done so that they can maintain the safety and security of the jail, the other inmates, the staff, all of those things. So it's done in every single situation. And because the evidence clearly showed that the Wake County Detention Center would have conducted lawful inventory searches, which would have discovered the evidence, again, the district court clearly erred in finding otherwise.
Can I ask a question related to Judge Hyten's earlier question? Is Davis and the cases that support it essentially a dead letter for urban police departments that have inventory policies that essentially Davis doesn't mean anything anymore, right? So there doesn't appear to be any limiting principle. If the police department has an inventory policy, the fact that the officers might have violated Fourth Amendment by conducting an unlawful search incident to arrest means that nothing happens because of an inventory policy.
Your Honor, I would say a couple of things to that. First of all, anytime we're talking about inevitable discovery, we're always talking about some kind of police misconduct, some kind of bad search. And on the spectrum of egregiousness, this type of search incident to arrest, which the court found bad under Davis, is sort of the low end of the type of police misconduct that we might see, right? The inevitable discovery doctrine comes from the Nix case, where the government would submit the police misconduct was extremely egregious. There, as this court is aware, the officers violated a defendant's Sixth Amendment right to counsel after promising the defendant's attorney that they wouldn't do that. So bringing it back, I would say
to rephrase the Chief's question in a slightly different way, what's a factual situation in which you'd ever actually suppress based on a Davis violation? Because it seems like in every single case, the government will just be able to make a winning inevitable discovery argument.
Your Honor, the inventory doctrine requires two things, both standardized criteria and action in good faith.
Let me rephrase.
Right?
As long as the government doesn't just totally screw up and fail to have a written policy, the government will always be able to avoid a Davis problem. Well,
it's not just when the government has a written policy. That policy has to, for example, cabin officers' discretion, as the Raleigh policy.
Great. Will cabin discretion by saying once you arrest people, search every single one of them.
Right. And that is reasonable, according to the Supreme Court, because inventory searches are an administrative function, right? It's important for jails and for police departments to ensure that defendants don't have contraband or weapons when they're taken into custody. So the inventory search is not an evidence gathering function. It's just an administrative function. And yes, to both Chief Judge Diaz and Judge Hyten's points, it will uncover this evidence in many of these cases. But this court has already found that type of inevitable discovery based on an inventory search to be lawful. I'd point you, it's unpublished, but to that Wilborn case, where this court had no problem upholding an inventory search-based inevitable discovery of a defendant's book bag that was searched at the time of his arrest, because those items would have been inevitably discovered. I see that I'm running out of time, but I also want to just note that the court committed legal error here too by adopting the defendant's argument below that the government had to explain why it did not get a warrant to search the defendant's property. As this court is aware, in the context of inventory searches and inevitable discovery, that simply is not required. I see I'm run out of time, so I'll cede to my colleague.
Let me ask you just one other question. It seemed like the court also relied on the fact that the wake policy was not in writing. I thought that our precedent suggests that it does not have to be in writing. It can be testified to by a competent witness.
May I answer Judge Niemeyer's question?
Yes, go ahead, please.
Thank you. Judge Niemeyer, I completely agree with you to the extent that the district court's order, I think the district court's order is not completely clear on that point, but to the extent that it faulted the government for not submitting the Wake County's written policy, that was clear legal error, because this court has been clear in several other cases that submitting a written policy is not and never has been required.
Thank you very much. Mr. Shive, I hope I said that right.
Yes, Chief Judge Diaz. Colin Shive on behalf of Appellee Milton Allen. May it please the court. I'd like to start by addressing the three different searches that Ms. Noakes identifies and claims would have been lawful inventory searches. The first was the one that took place at the scene of the arrest. And picking back up on the questions from Chief Judge Diaz and Judge Hytens, we believe that this policy is impermissible under Diaz and the Fourth Amendment and in the United States Supreme Court decision in Illinois versus Lafayette. As Chief Judge Diaz noted, this policy would render Diaz a dead letter, and the Raleigh Police Department can't, through policy, turn an illegal search into a legal one. The whole notion of inevitable discovery.
Well, it's also a little bit weird to say that a Fourth Circuit decision can gut a doctrine established by the Supreme Court. Like, I'm not aware of it's the obligation of a lower federal court to strain to make sure that our decisions construing the Fourth Amendment aren't rendered a dead letter, and as a result, we can just make an exception to a Supreme Court doctrine.
Well, Your Honor, I think that language from Illinois versus Lafayette provides direction to the court in that regard, because there the Supreme Court noted that the factors justifying the search, an inventory search, at a jailhouse when the defendant arrives at the jailhouse are different than at the scene of the arrest. And the Supreme Court there then held that at the station house, it is entirely proper for police to remove and list or inventory property. So that's distinguishable from the case here, where the illegal search is a search incident to arrest, and the government is now just attempting to say that, okay, we
Right,
can...
that's the search they did here, but under inevitable discovery, we have to ask about the search that they could have done and whether that search would have been done. So, like, I mean, you know the fact pattern. The fact pattern is fine. They don't search the bag there, but they placed him under arrest. They're going to bring the bag to the detention facility because they're not just going to, like, leave it on the side of the road or hand it to some random person. They're not going to do those things. So they're going to bring it to the detention facility, and when it's at the detention facility, it's going to be searched because they don't let bags into the detention facility for reasons that seem so obvious as to not require comment.
Correct, Your Honor. I think there are two things there to inevitability. One is that here in this case, the defendant did not go straight from the scene of the arrest to the detention center. He went to at least to one, if not two different hospitals. And none of the officers who testified at the suppression hearing were able to testify about the chain of events that happened from the scene of the arrest until the defendant got to the detention center. Officer Easterling, for example, testified that he knows that the defendant went to one hospital, possibly two, he couldn't say. There was no testimony from the other officer about that. And the lieutenant at the detention center who testified says that he does not know where the defendant went from the scene of the arrest to the until he got to the detention center. And the Supreme Court noted that important point again in Illinois versus Lafayette when they said, and I quote, "An arrested person is not invariably taken to a police station or confined," and end quote. And we'd submit that even here, and that even when they are, it's not invariably the case that arrestees' personal belongings will follow them there. For example, in United States versus Wilborn, the unpublished Fourth Circuit case that Ms. Noakes cited and referenced in her argument, there was testimony from the officers that there was nobody else on site for them to hand the bags to. So there could have been someone on site for them to hand the bags to. I understand in the government's reply brief, they have reviewed the body cam footage and saying that it doesn't appear there was anybody there, but there's no testimony to that.
This is now the argument that maybe his bags would have not ever reached the detention center. That's the argument we're making right now.
I believe it is possible.
But my follow-up question, where, if anywhere, did you ever raise that argument to the district court?
We did raise the argument the government had not met its burden with respect to inevitable discovery.
Did you ever say the government has not shown that the bags would have actually been brought to the detention facility? Did you ever say that to the district court?
No, Your Honor, we did not. But this court can...
Let me ask you, is the record clear that when he was arrested and taken to the hospital, the bags were not taken to the hospital?
We have no idea.
Yeah.
We have no idea where the bags went.
And let me ask you, if the bags were still on his body when he was arrested, could the officers have searched the bag while they were on his body?
Under United States versus Davis, yes, they could have, because they would have been within his reach during that time if he was unrestrained and could have reached them. Correct.
So the whole thesis here about police misconduct is because the bags were removed 2 feet away and he was under control, that the search they conducted there was not proper, but they could have conducted the search on his body incident to the arrest.
And the reason for that, Your Honor, would be because of officer safety.
Is that the only reason for a search? Isn't there also a reason for the preservation of evidence? Safety and collecting of evidence?
If law enforcement had believed that there was evidence of a crime in that bag, then they could have held the bags and obtained a search warrant.
No, it's on his body. They don't know. And you just told me they could search it if it's on his body.
Correct, Your Honor.
All right. So if they can search it while it's on his body, but they can't search it when they've removed it from his body and put it 2 feet away, this is what we're facing in this case. And I know this is not the direct issue before us because Davis is contrary to that. But I'm just thinking in this idea that here you have somebody, it took him 5 minutes to take down. He had these bags. They took them off him and laid them aside before searching him. Well, they could have searched him when they were on his body. And they're going to arrest him. But before arresting him, they had to take care of his injuries. Presumably, we don't know this directly, they seized the evidence and held the evidence. And of course, once they seize the evidence in their possession, the 2 bags, at some point, they're going to inventory it.
They would inventory them if the bags would inevitably arrive at the detention center. And I do believe that it's possible that something else could have happened to the bags in the meantime. A loved one could have taken them at the hospital. The defendant in this case was taken to the hospital because he had chest pains. It's certainly reasonable that a member of his family could have been alerted to that. And if he's at the hospital, he could have given his bags to them. And if not, I would ask why not? If this is not an impermissible ruse for searching, then why would the law enforcement not provide an arrestee an opportunity to hand the bags off to someone else? As to the 2 different searches that take place at the detention center, we believe that the testimony of the lieutenant about the initial pat-down phase of the search is ambiguous and unclear. The lieutenant says that once an arrestee arrives at the detention center, they're brought into this initial search area, and a pat-down search is conducted. The government attorney at the suppression hearing then said, does that search, referring to the pat-down search, does that search apply to personal belongings? And he says that it does, but he doesn't say what that search involves. He does not say it's an inventory search. He does not say that bags are opened, all the items are removed, and analyzed to see if there's contraband or anything else. He just says that the pat-down search, however that would apply to personal belongings, occurs at that initial search in the search area. And then afterwards, after the defendant is held for a while and it's determined whether or not they're going to be released, if they're going to bond out or otherwise be released, then an inventory search takes place. And the government has the burden of showing that inevitably these bags would have been subject to an inventory search. And an inventory search was not described with respect to that first phase. The government makes the point today that the defendant didn't bond out. Well, we submit that's entirely irrelevant because possibly the reason he didn't bond out is that he was charged with felon in possession of a firearm and major drug offenses because this illegal search had taken place. If that illegal search had not taken place, the charges that he would have been brought in for would have been far more minor, and it's certainly possible that he could have bonded out in that case. And we don't know if the bags would have been searched then. It's unclear. And reviewing the record in the light most favorable to Allen, the prevailing party below, we believe that the lieutenant's testimony is ambiguous in that regard. And the district court did not commit clear error in finding that the government had not met its burden.
So could you just articulate for me again what you think the district court meant when it said, that's Chief Justice Berger's legacy, inevitable discovery, one of my favorite cliches of all time. Yeah, okay, inevitable discovery is going nowhere. What is your take on what the district court meant other than what the district court seems to have clearly said? I don't like the inevitable discovery doctrine and I don't intend to apply it here?
Your Honor, I can't say for certain what Judge Boyle meant when he said that. I believe that regardless, he showed in his opinion in this case that he believes the inevitable discovery doctrine is alive and well because he applied it and cited the relevant precedent.
Well, now I'm looking at the district court's suppression order and I don't understand why there's a sentence in here. I agree the district court didn't in its written order just refuse to apply the inevitable discovery doctrine, but the court is going through it. This is on JA 204. So the court says, the court is not persuaded that the officer testimony, which largely focused on the thoroughness of the search, contained enough particularity. That, I agree, is a 100% relevant question under the inevitable discovery doctrine. But then immediately after it is the following sentence. Further, the government does not explain why the officers could not have seized and held the bags while waiting for the warrant to issue, complying with the strictures of the Fourth Amendment. That is in the center of the court's legal analysis. And it seems completely legally irrelevant. Do you agree that under the inevitable discovery doctrine, that remark is completely irrelevant?
I agree that it's irrelevant under the inevitable discovery doctrine. I would submit that at that point of the opinion, stop the court's opinion at the end of the sentence beforehand, and the judge has concluded his analysis under inevitable discovery, and at that point he is simply noting...
Well, the whole problem then is the very next sentence of the court's opinion goes right back to talking about exceptions to the Fourth Amendment and exceptions to the exclusionary rule. I mean, it seems to me that it's lodged smack dab in the middle of the court's analysis of the inevitable discovery issue.
Again, it's possible that the court was saying that, well, since inevitable discovery doesn't apply, the court has also not, or excuse me, the government has also not shown any other justification or exception to the warrant requirement here. And regardless, Your Honor, I believe it's dicta, and I believe it's not essential to the court's holding, and that this court could uphold the district court's ruling, notwithstanding that statement.
Okay, can I ask you about your sort of this would gut Davis argument? Which, look, as a practical matter, has a lot of force, I get. The government's response, though, I'm not really sure you have a response to. Like, you could say the exact same thing about applying inevitable discovery after Gantt, right? Like, Davis basically takes Gantt and extends it outside the Carr context. And the government represents, and my research seems to indicate, I mean, everybody's applying inevitable discovery to Gantt violations, and couldn't you make the exact same? This is going to render Gantt a dead letter, because like if you can just get it around Gantt via inevitable discovery, then Gantt is not in the real world ever going to do anything.
Your Honor, I would respond to that by noting the cases that were cited in the government's reply brief. I believe in each of those cases, I'll just take United States versus Rux as an example. It's a Ninth Circuit case. Where they had testimony from an officer that at the suppression hearing about the fact that the vehicle would have inevitably been impounded and taken into custody. So there was an officer who testified.
Oh, no, sure. No, that's an argument about whether the testimony in a particular case is good enough to establish the factual predicate for inevitable discovery. That I get. But I understand a major thrust of your argument to be like, you can't allow inevitable discovery in this situation, because if you do, a reasonably competent series of law enforcement officers can render every single Davis violation inevitable discovery. And like I guess that's a conceptual point, not a point about the evidence in particular cases. And there is some intuitive force to that for me, but then it occurs to me, you could say the exact same thing about allowing inevitable discovery for Gantt violations, and yet it seems that we in every court of appeals to have considered the question have said you can have inevitable discovery for Gantt violations.
Correct, Your Honor. You can have inevitable discovery for Gantt violations, assuming that the requirements of inevitable discovery are met. And so
yes, but I'm saying one of the things I understand your brief to be fighting is the idea that you can ever have an inevitable discovery for a Davis violation, because you have this thrust in your brief that said that would gut Davis. Again, right. I think you have two arguments. You have an argument about the facts of this case, about whether inevitable discovery has been made on the facts of this case, but then you also seem to have this broader argument that there really shouldn't be any sort of thing as inevitable discovery for Davis violations, and that's the part of the argument I'm asking you about right now.
Correct, and that's true, Your Honor, and we felt compelled to make that argument given the clear language of Davis. And I understand your argument about violations in respect to Gantt and inevitable discovery. At the bare minimum, Your Honor, I would say that the Raleigh Police Department's incredibly broad, limitless policy of always, regardless of the circumstances whatsoever, without any showing of inevitability of the arrival of personal belongings in a detention center, that the police officers have carte blanche to conduct inventory searches of personal belongings of individuals they arrest at the scene of crimes. I'd also like to address the argument that Ms. Noakes made.
Mr. Shive, I'm sorry, can I address that, ask you about that point? Are you making that argument because a search at the scene of the alleged arrest is not really an inventory search in the sense that we often think about it?
Correct, Your Honor. I think it would be an impermissible ruse for searching, to quote Florida versus Wells. And
so under your world, an inventory search would only be proper at a jailhouse? Is that?
That is how it was described by the Supreme Court in Illinois versus Lafayette. The justifications for the inventory search are so that weapons and contraband don't make it into the jailhouse. And so there's no reason for that search to take place before unless the weapons or contraband were going to arrive at the jailhouse.
I think
Go ahead.
Go ahead. I was going to say, I'm wondering, and maybe this is just an intellectual curiosity, but we're talking about unreasonable searches and seizures, and the Constitution bunches those together, search and seizure. And so we arrest somebody and seize them because we have probable cause they're committing a crime. But yet then we restrict ourselves from searching them because I don't know why. And Gantt, of course, is an opinion which basically says you can't search even though you could seize. And I'm wondering whether the Supreme Court will ever review this or whether they tolerate the inventory search basically as a mitigating factor. Because when you arrest a person who's committed a crime or the probable cause to commit a crime, you seize them and search them. And I don't understand why we have a restriction on everything. The only exception I would make conceptually is the new phenomenon of a cell phone, which the Supreme Court has recognized as a different category altogether because it's such a broad container of information. But aside from that, I wouldn't be surprised if the Supreme Court took one of these cases and reviewed this altogether and went right back to the Fourth Amendment and equated searches and seizures and linked them to probable cause and not to some other aspect. But that's just a curiosity. You don't need to answer it, but you're welcome to comment.
I was going to say, Your Honor, that is far, far above my pay grade.
Well, it's above mine too. You know, I'm just a lowly Court of Appeals judge. So,
I mean, I would offer that, you know, in this case, we're talking about, you know, personal belongings, you know, closed containers that the government at the time of the arrest, that they don't have anything to do with the basis for which the defendant was arrested, and that would apply here to many other cases.
And that might be a more limiting factor. In other words, but here this would be a perfect example. Here they have a probable cause that this man committed a crime in their presence, and they arrest him. And it seems to me whether they search him with the bags on his body or on the street next to his body would make zero difference. They are seizing and searching in connection with a probable cause of a crime being committed. And searching is just as productive as the seizure. The seizure has this purpose, and so does the search. And it's not just safety, in my judgment. It's also evidence, further evidence of the crime. Gantt doesn't say that, at least with respect to automobiles. But I derive that, though, in thinking back, what is reasonable and not reasonable under the Constitution, and that's the foundation on which we're building all this. And the inventory search has been allowed, and as you point out, it tends to mitigate the protections of Gantt and all the others. Perhaps in many cases, just making them hollow. But it seems to me that may be a deliberate decision of the Supreme Court in view of the fact that they have got somebody pursuant to probable cause. Now, of course, if there's a question about that, that's something else. But I'm assuming they have a good reason to arrest somebody, and they arrest him, and they should be able to search him and everything about him. That could be relevant to the crime. That said, I withdraw all that, and unless you want to have this law school debate.
The only thing I'll say about that is the hollowing effect of the inevitable discovery doctrine and the inventory search. I mean, given that it has that effect, I think is why it's important that it be narrowed to its justifications as articulated by the Supreme Court. And
fair enough.
And if I may, Chief Judge Diaz, just one really quickly about the written policy issue.
Go ahead.
So obviously the government can meet its burden through either a written policy or testimony. We submit that it did not meet its burden here through the testimony. So then what it's left with is what it submits as its documentary evidence. And here what they submitted is the Raleigh Police Department manual talking about all different kinds of searches and seizures that they undertake, and it has one small portion about that which says that they conduct inventory searches pursuant to the Wake County Detention Center's policy, but it doesn't provide that policy itself. And I think it's fair for the district court to say, well, if I don't think that the testimony about the policy was sufficient, it would certainly be helpful to have to see that written policy as well, and they didn't have that.
All right, thank you very much, Mr.
Thank you.
Schott. Ms. Noakes?
Thank you, Your Honor.
I had to do a double take because the government usually doesn't get rebuttal, but.
Yes, Your Honor. I want to address this point about the policy violating the Fourth Amendment. My colleague started his argument by saying he believes the Raleigh police policy violates the Fourth Amendment, and that's the first time that's been argued, is that policy violates the Fourth Amendment. He also says that if it's not a ruse for sort of the general rummaging or searching for evidence, then why doesn't it give officers discretion to hand that property off to somebody else who may be at the scene or wherever? And in answer to that, I'd point the court to the Say case, S-E-A-Y, where this court said that these policies should limit discretion as much as possible. They can have some discretion, but they should limit that discretion as much as possible. And in that case, the court was looking at a policy that required inventory searches of all of an arrestee's property, even if the police were going to hand that property off to a family member or a friend. So that policy did give the discretion to hand the property off, but it required inventory before doing so. And this court did not have a problem with that policy. So to the extent that there's an argument here that this policy violates the Fourth Amendment, first of all, that was not submitted to the district court. And second of all, this policy is in line with this court's precedent on this issue. I want to address the argument that the bags might not have made it to the jail. First note that the defendant didn't make this argument to the district court, and there's certainly no indication in the district court's order that it relied on this or even considered this. As a threshold matter, the defendant admitted before the district court that there was no one on the scene who could have taken the bags for him. So this is not a matter of the government eagle-eyed watching that body camera video that has been provided in the appendix volume 2. This is defendant's admission at JA 17 and 20, where he says that there were no bystanders who could have taken the property at the time of the arrest. So if the bags were going to be waylaid somewhere, it would have, I guess, had to have been at the hospital. But there simply was no evidence that would have even been possible. In fact, the evidence is contrary. The Raleigh Police Department's policy allows for evidence to be secured by somebody that the person in control of the property designates. This is the second paragraph of the policy at JA 159, but only after the conclusion of the inventory search. So the evidence shows that these items of property would have been searched even if Raleigh police would have then given them off to somebody at the hospital. The policy is clear. They're required to do this inventory search. And if they're going to hand the bags off, it has to be done before that. But there's nothing in the record that even hints that this property would have been treated differently. And the court dismissed this sort of speculative, well, things could have happened differently, again, in that Say case, where there the defendant said, well, if the police hadn't searched my bag, I might have told the police that actually it belonged to somebody else, and then they might not have done the search. And the court dismissed that speculation. That's just what we have here. Bare speculation that the bags might not have made it to the jail when the policy shows that the evidence would have been searched before being handed off to somebody else. And the testimony by the jail lieutenant was that typically every arresting agency brings personal property of the arrestee to the detention center when the person is brought to jail. So the evidence before the district court supported a conclusion, and only one conclusion, which was that the bags would have in fact made it to the detention center, where again, they would have been subjected to searches. In conclusion, Your Honors, the court clearly erred in finding the government's evidence did not contain enough particularity to show inevitable discovery through at least one of the searches that would have been done, one of the lawful inventory searches by the Raleigh Police Department and the Wake County Detention Center. The evidence clearly showed that the police lawfully could have and would have uncovered the evidence. The simple fact is that the defendant's guns and drugs would not have made it into the jail without being found. Their discovery was inevitable. And so we're asking this court to reverse and remand the district court with instructions to deny the motion to suppress.
All right, thank you very much, Ms. Noakes. I want to thank both counsel for their very able arguments. Mr. Shive, I want to thank you specifically for your willingness to be court appointed in the matter. Mr. Allen was very well represented, as was the United States in this case. So thank you both for your arguments today. We'd normally come down and greet you, but we can't do so given the circumstances. But we very much appreciate your being with us today.
Thank you, Your Honor.
Thank you.
And with that, I would ask the clerk to adjourn court. Sani Da.
This honorable court stands adjourned. Sani Da. God save the United States and this honorable court.